before the statute of limitations runs. And then even before the statute runs, they put service in the mail to State Farm. But then there's issues with the post office. It doesn't get there. And so State Farm is not served until only six days after the statute's run is when State Farm is served in this case. And so then State Farm files a motion to dismiss, which is granted. And then on appeal, the court says, yes, absolutely. And so in that case, because they didn't follow up with the post office, they couldn't rely on the post office, that they were not diligent enough. And so you have in that case actually where the plaintiff made an effort to serve them before the statute expired and was only 6 days late. And the court said that's not sufficient diligence and upheld the dismissal of State Farm. This case is even easier. There was no effort that we have any record of to serve Progressive until well after the statute had run, until 61 days had elapsed. And so there, in the absence of any showing of diligence, a 61-day delay cannot be excused. And I don't think the court is in the business of rewriting the law for the legislature and eliminating 33-711, which clearly states that we get to play by the same rules as any named defendant. And in this case, Progressive is not trying to take advantage of any loopholes or technicalities or anything like that. All the Progressive is asking is just that the rules be applied. And clearly the rules here is that you must serve the defendant, if it's a UM carrier or not, within the applicable statute. And if you haven't, then you need to show diligence. And the burden's on the plaintiff to show diligence. And that hasn't happened here either. There's nothing in the plaintiff's response to our motion that says, well, we tried, we did this, that, the other. There's nothing. They sent notice in June to Progressive, but the law is quite clear. Notice is not a substitute for service. If notice was, then the statute of limitations would lose all meaning. And all you'd have to do is give somebody notice of a lawsuit, and then the statute essentially would go away. And so notice, and I'm aware of no case on point that says notice is applicable. And I believe in Moat, State Farm did have notice as well. So Moat is directly on point. I think it's a very well-reasoned and recent opinion, and it clearly shows what the state of the law in Georgia is. And so from our perspective, if 6 days doesn't show enough diligence, and that's too late, then clearly 61 falls into the area where the only result here can be dismissal on both of these.
Okay, perfect. Thank you, Mr. Baker. And Mr. Wheeler?
Yes, Your Honor. Well, like I said, the plaintiff's position is that this is different with Progressive being an unnamed defendant. Moat is correct where the plaintiffs in Moat named State Farm, the UIM carrier, as a defendant. Here, Mr. Lane, or in the 301 Justice CRC, did not. They named the defendant Dakota Sullivan, insured by State Farm, where service was perfected on defendant Sullivan in time, and copies of the lawsuit, the discovery documents, complaint, summons, all that were sent out on June 18th, 2024, which was before the statute of limitations told. Progressive filed an answer in their own name. That was on April 16th, 2025. That obviously changes them from an unnamed party to a named party. But up until that point, the relationship between Progressive and plaintiff is contractual. That is a company that plaintiff has hired to provide them with uninsured motorist coverage in such instances like this, where the available coverage for the at-fault party is insufficient. And they're not a tortfeasor. The disputes between Progressive and plaintiffs are contractual disputes, which would be subject to a 6-year statute of limitations. When Progressive filed in their own name, they became a named party, and that was after they had already been served, copies of the lawsuit, served properly, service was perfect, by the time that Progressive filed their answer and became a named party moving forward. Yeah, again, I would argue that there is a distinction between a named party and an unnamed party, and most, if not all, of the cases referenced in Progressive's brief were where plaintiffs chose to bring an action directly against an insurance company named as a defendant, as a joint tortfeasor from the initiation of the action.
Okay. So walk me through this distinction you're drawing about the named versus the unnamed one more time, just a little more slowly.
All right. Progressive wasn't a named party to the lawsuit. Therefore, there would not be a direct tortfeasor. Any disputes between them are a dispute between the plaintiff and the insurance company that they have entered a contract with for coverage.
And that's where we get to the
6-year
Okay.
issue. Now, once they file an answer in their own name, they become a named party, a named defendant. That was after they already had, been served. But up until that point, it was a contract dispute between Mr. Lane / Jessica Searcy and Progressive.
Okay. Now I'm tracking what you're. Now I'm tracking what you were trying to get me to follow. Okay. Anything else?
There was nothing that compelled Progressive to file the answer in their own name. The defendants had already filed in name. The Dakota Sullivan and the attorney who was here earlier, hired by State Farm to represent the defendant, they filed the lawsuit, in their name, and Progressive took it upon itself to file the lawsuit in the name of a party. They did not have to do that. So that would change the nature of them being an unnamed party, the UIM carrier attached to a lawsuit with named defendants to now a named defendant, which would then, let them make an argument that the statute of limitations was breached. But there was nothing that required them to answer in name. They did that, switch from a 6-year statute of limitations to a 2-year statute of limitations.
Okay. All right. Thank you for that. Any response?
Yeah, Your Honor. I mean, I would just have to say that doesn't make any sense. I don't know how I'm going to assert my motion to dismiss based on the statute of limitations unless I file an answer so I can do that, right? If I file an answer in the name of the defendant, I'm not really positioned to file a motion to dismiss the insurance company on a statute of limitations defense. The idea that there could be a transforming statute of limitations, and in fact, if you look at the wording of 33711D, that a copy of the action, this is kind of towards the end, a copy of the actions and all pleadings thereto shall be served as prescribed upon law upon the insurance company issuing the policy as though the insurance company were actually named as a party defendant. So the statute says this. There is no magic wand for me to transform this from a 2 to a 6 sliding scale. That doesn't exist. And I would say in Moat, the reason why State Farm is named in the lawsuit there, as far as we know, is because they're the appellee and that's defending the appeal. So and the case that plaintiff cites, it shows that the UM carrier has the option to change whether it defends in its own name or defends in the name of the defendant, up until the time of trial. So we can defend in our name or not, depending based on what the statute is. And the statute doesn't say you have to be named. If they wanted to say that, they could have, but that would create just a universe of confusion. How I can go from having a 2-year statute of limitations to a 6, depending on how I answer the pleading, that doesn't really make any sense. And there's no other mechanism for Progressive to get involved in the case to assert its rights. And that's kind of the big picture that I think plaintiff is missing, is that yes, Progressive is an insurance company, but it's still a defendant in Georgia State Court. And the legislature has given this defendant certain rights. And those rights just can't be evaporated based on a creative argument when they're written in black letter law and when they're supported by a long line of case law. Obviously, imagine the headaches this would create if 6 years later, after a case has been resolved, now a UM carrier is going to be sued under a 6-year statute of limitations theory. It doesn't make any sense. And so I think they get points for creativity. The law itself is quite clear. This is not a 6-year statute of limitations situation. It's a 2-year statute of limitations situation. And they can't, and because they were not diligent, they've crafted an argument that sort of expands the playing field. But really the only question the court has to answer, and that when the only thing that they cannot provide you with is some evidence of diligence here. And that's really where the issue is.
Okay. All right. And I'm tracking both. And to be fair, y'all are both correct in that your two theories cannot exist in the same universe. So it's either one or the other. So, I respect that. And this is not the first time I've been in that position. So, okay. Do y'all have anything else you want to bring to my attention or put on the record before I kind of start to wind us down?
I would request too that the court finds that the delay in service after if the statute of limitations for this is 2 years, relates back to the filing of the lawsuit. There hasn't been any demonstration of undue delay, unfair prejudice, or any of hindrance on Progressive's ability to defend this action. This is something that they've been on notice of since at least 2022. There isn't anything at all that plaintiff has done or not done that would, constitute latches here.
Okay. And I appreciate you putting that on the record. Anything else?
I would just respond that prejudice isn't the inquiry here. It's simply diligence. And so, in the absence of diligence, Moat and its predecessors make it clear there's really only one result the court can reach here. And a 61-day delay, it just falls outside of that.
Yeah, and like I said, I very much am following each of you and the idea that it really is either all the way over here, or all the way over there. That I've got to pick one. So, okay, I understand that. Anything else? Let me check it out. Yeah. Okay. So, just circling back to I've been hearing your arguments in both 303 and 301 at the same time.
Correct. Okay. All facts, dates, arguments are going to pertain to both of the cases on the record. One of them would be 24SB 301, the other being 24SB 303. Jessica Searcy is the named plaintiff in 301. Charlie Lane is the one that was calendared for today, 303.
So, of course, it's not going to be a surprise to you all when I say I'd like proposed orders. Am I correct in thinking the proposed order could have both case numbers at the top from each of you?
Sure.
Okay.
I've submitted proposed orders already. I can recraft them and put them all together.
Oh, okay. I'm just used to saying that in the end. It's just the script I say.
Yeah, no, sure.
I think you've got proposed orders from plaintiffs as well, but I can.
Yeah. Y'all have a cross claim, so don't you?
Yeah, I mean, if we're dismissed, we will withdraw the dismissal cross claim as well. So that would be, I mean, I could amend my order to put that in there and say that, I mean, obviously, if we're dismissed, then we're not paid anything. We wouldn't be pursuing anything.
That's fine. I had forgotten about the cross claim. I was only thinking about whether y'all were in and out in your current official state. But,
sure.
But thank you for that, Mr. Hope. And so that means that if y'all do that, in the proposed orders, the idea would being that y'all would be out altogether, and then obviously on your end they'd stay in altogether, and we'd sort out the cross claim at some later date on some later issue. So, okay.
Well, the cross claim would be resolved.
No, I'm saying if I was on his lane. Remember, I got 2 lanes.
Yeah, right. Yeah, they would have to recover. Yeah,
I got 2 lanes and a double yellow line in the middle, and I have to pick a lane. So.
Yeah, and the one other thing I would add, Your Honor, the only thing to me that was a little tricky that made this case unique is that the one exception to the statute of limitations is we didn't know, that we were underinsured. And in this case, the pleadings indicate are already in excess, and I address this in the motion. The medical damages claimed are already in excess of what the underlying limits were. So that argument, and they didn't even really make it, but just to be, thorough about it, that is why, typically we kind of have to wait to file these because we don't know. But in this case, we saw the pleadings and we knew because they've already exceeded, what their claims already exceeded the underlying limits. So that would not apply either.
Okay. All right. So you've already submitted your proposed orders. We've got, if I go this way towards the defense, that will resolve the cross claim. If I go this way towards the plaintiff, we'll resolve the cross claim at some later date. We've already got proposed orders. Any other housekeeping or anything else? We'll start with the plaintiff before we wrap up.
I think that there is a minor plaintiff who might be named on the 301 action. None of this.
Yeah, he is. I'm sorry. He filed a separate claim, right? And
Right.
his we don't know yet on him. So I've got to do a little discovery to figure out what where he was. On the two adults, it was clear based on the damages pled that he did not qualify for the exception under the statute of limitations. So the other one, we have to see.
Okay.
But if nothing changes, I anticipate we would probably, maybe we can work something out depending on how this goes. But that is not ripe yet from our point of view.
Okay.
And also, I would say that I'm happy to modify my proposed order to specifically say that Progressive consents to the dismissal of its cross-claim with prejudice if we're dismissed from the case, because that's not would be a non-issue.
All right, I do want that, just so that it's exactly as it sits today. And because I don't think you need to make any changes to yours.
No, Your Honor.
Unless you're
Well,
thinking,
let me look at it just because, like I said, in lieu of our 6-year argument,
Yeah.
we would argue that the 61 days relates back and that the heightened standard for diligence hadn't been triggered until the answer was filed. So let me just look and see what I submitted. It's been a while.
I'm great with that because part of what I was going to do when I left the bench was take your proposed orders and compare them to my notes from our hearing. So to know, frankly, that y'all's proposed will be updated to match what we're talking would be great.
Great.
Now, as far as this other plaintiff, do y'all represent
The minor?
the minor?
We do, Your
Okay,
Honor.
so y'all have the whole universe of all the plaintiffs.
Correct.
Okay, great.
And I've got all three of them.
I
too.
thought that was true. I just wanted to ask it out loud to make certain
Sure.
that what I'm, it's always good to just go, let me make certain I've got this right or I've got this wrong. So, okay. Anything else?
No, Your Honor. Thank you.
Okay. Anything else?
I would just say, Your Honor, I believe they just reset depositions for November 21st. My clients would probably want to know if I've got to go to those or not.
Yes.
So, and I'm happy to get you, the updated order by the end of the week or whatever. It shouldn't take me more than a minute to craft that. But if you want to give us longer, I understand.
Yeah, let's just do 10 days. That's a good number.
That's a good number, yeah.
Does that work for you as well?
Yes, Your Honor.
Okay.
So
All
that
right.
is
Well,
20.
let's look at the calendar and see where 10 days falls. That's a better way to do this.
I agree.
So today's the 10th. So the 20th of September is, it's a Saturday. So we'll roll that over to Monday. So y'all have until the 22nd.
Very good.
So just get us something by close of business on the 22nd that's updated, which is fine because as you already caught, I'm in trials next week.
Right.
And then that'll get me out of that. So that'll get me through that. All right. Y'all need Ms. Bando, we're gonna handle your case when we get back from the quick break, okay?
Okay, thank you.
All right, thank you. Ms. Bando, we're going to change just a little bit. We're going to do a tiny piece of the Campbell case, and then we'll circle to yours.
Okay, thank you.
Oh, defense over here.
Oh,
So-
I'm so sorry.
That's okay. That's all right. That's all right. That's all right. Mr. Monahan, you there?
Yes, Your Honor.
Okay, we're going to go ahead and do just a little piece of the Campbell case. Because I believe somebody's got to get out of here for a minute. So, yeah, so she's got an appointment. So we're going to go ahead and knock this out of the way and let her do her part, and then we'll circle back. All right, you ready, Mr. Webb?
Yes, Your Honor.
You ready?
Yes, Your Honor.
Okay. If you'll, and then Mr. Monahan is virtually, so if you'll just state your full name, so we've got everybody. Mr. Webb, you first. Full name?
Orion Webb.
Suzanne Smith.
Matthew Momptahan.
All right, go ahead.
Your Honor.
Yeah, just grab that. It'll move all around.
All right, sweet.
It'll pull all the way over to you.
Mr. Webb and I have reached an agreement as it pertains to my client, Mandy Campbell. If at all possible, I'd like for him to speak to that agreement because I think he has a better sketch and outline, and we're agreeable. And we are happy to work with him.
You good?
Yes.
Go ahead.
All right. So Ms. Campbell agrees to the scary fascist reviving the initial judgment. And in addition to that, she's going to give full responses to the post-judgment discovery through her new counsel in 4 weeks. I don't have an exact date, but I'm not really worried about it with this particular attorney.
No.
In 4 weeks. She's going to make a few statements on the record about the assets of the Campbells since 2017.
All right,
The deeds in particular.
let's bring, if we're going to do that, if we're going to get into the both of their stuff, I'm just going to bring Mr. Campbell up. And I don't know, Mr. Campbell, come sit over here by me. So I'm not going to put you all at the same table.
And we are withdrawing our motion for contempt as to Mandy Campbell, but not James Campbell, based upon the representations I understand she's going to make. And then, further, we're working towards putting a mortgage on the property, but we've got to talk to Mr. Campbell's divorce attorney about that.
Okay, and we'll do that part here just a bit. I'm just having you up here just so that you're part of this. And that your attorney can see that you're here, but I don't anticipate needing to hear from you.
If it's acceptable, I can make a proffer and ask her if that's correct. The facts would demonstrate that in the recent past months, the parties, Mr. Campbell and Mrs. Campbell, are divorcing. And as part of that divorce process, Mr. Campbell departed from the home. Upon his departure from the home, Mrs. Campbell located a copy of a deed that conveyed ownership interest in the Spalding County property upon which there is a judgment lien. And it conveyed that piece of property to Pauletta Owens. That was one deed, and then there's another deed conveying the ownership interest back. Upon discovering that deed conveying ownership interest back in the Spalding County residence, Ms. Campbell reached out to me, and I filed in a notice of lis pendens in the divorce proceeding. And I arranged a meeting in person with Mr. Campbell to retrieve the original of that deed, which I was successful in doing. And that therefore was filed of the court, the real estate clerk's office.
Okay. All right, and if you'll confirm with your client that that's accurate.
Ms. Campbell, is what I said true, correct?
Yes, that is.
All right, not sworn testimony, but this is not a hearing. This is simply a statement by the attorneys as to what y'all anticipate your agreement is between you, and I'm simply just notating that. So I just want to put on the record that this is not testimony subject to cross. It is simply a statement by the attorneys, unless y'all wish it to be formal testimony.
Yes, so what we discussed was her stating on the record,
Okay.
in particular, with regard to her lack of knowledge of this deed until the divorce.
Okay, well, let's put it under oath. Raise your right hand.
Yes.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
All right, take your hand down, grab that mic, pull it over, lean in. It gets really close. It gets really loud if you get really close.
Okay.
All right, so you're officially under the record, which means that if Mr. Monahan, who we still haven't quite established his role here quite yet, we're about to do that in a minute. But obviously, Mr. Webb may ask some questions. If Mr. Monahan is going to continue representing Mr. Campbell, he'll get to ask a few questions. And if not, we'll go from there. Okay? All right, so back to you. So if you'll please confirm that what your attorney stated on the record is true.
Yes, it is true.
All right. Mr. Monahan, is it your intention for me to continue your motion to withdraw, or are you wishing to continue representing? So obviously you're out with Ms. Campbell because she now has counsel. Is that acceptable that I'm removing Mr. Monahan as your attorney?
Yes, sir.
Okay, so you're out on one. Are you wishing Mr. Monahan to continue with Mr. James Campbell, who is seated here to my right in the witness seat? Or are you wanting to withdraw from the case altogether?
Your Honor, I wish to withdraw from the case altogether.
Okay. All right. That's fine. That's what I expected. And I'll go ahead and state on the record that I am of the opinion that you never had an obligation here at all. Your representation in this case ended when the last one closed. And that when you got back involved, I thought that was just you, frankly, going above and beyond. So I just wanted everybody to know that I had a lot of respect for Mr. Monahan. He got involved in a case that he had every right to say, nope, I'm not opening the file and I'm not taking any calls. So I appreciate the efforts you took up to this point to protect your client who's sitting here beside me and your other client who now has counsel. And do y'all have any objections to me cutting Mr. Monahan loose?
No, Your Honor.
No, sir.
All right, you may disconnect. Thank you so much.
Thank you, Your Honor.
All right. Any questions that you want to ask Ms. Campbell, and then I'll come over to you in a minute.
Yes,
Okay.
Ms. Campbell, hello. Orion Webb, we've met before.
Yes, yeah.
The deed that you discovered is dated September 21st, 2020. Is that correct?
Yes, sir.
All right. When did you first learn of this deed's existence?
When he was gone after the divorce, after he was served papers.
Okay. And that was within the last 2 months?
Yes, going on about 3 months.
Okay. Prior to that, from whom did you get your understanding of the ownership of your residence?
I mean, it was James. Yeah,
You were relying on James's
I was.
representations?
I was.
Okay.
Yes, sir. And unfortunately, I was let in the dark this whole time.
Okay,
About
so
what was going
your prior discovery responses and deposition testimony, that was relying upon the representations of Mr. Campbell?
Yes.
Okay. And is it your understanding that this deed was entered on September 21st, 2020?
Yes.
All right. And since that time, has Mr. Campbell presented you with any other deeds transferring assets between him and his mother?
Yes.
All right. And is that a transfer of Mr. Campbell's ownership interest in 348 Mercedes Avenue, Panama City, Florida, 32401?
Yes. That's where his mother lives.
Did you get that? Okay. And were you aware prior to that Mr. Campbell had an ownership interest in that house?
I'm not sure particularly of that house. I just found out that he had property in Mexico Beach, Florida. I'm not sure the exact address of that, but it's Gulf Air, Mexico Beach.
All right. How many real properties, and real property means like land or houses, how many real property ownerships does Mr. Campbell have that you know of?
So including, well, now mine, and so his mother's at 348, and then the one in the Gulf Air, that's 3, and then it's possible that he has older daughter that lives there as well. She has a new house that I know Miss Owens, his mom, co-signed with her on. So who knows?
And And that's almost all I've got, but I just wanted to clear something up about his employment status and income since 2017. From 2017 to present, how often was Mr. Campbell employed?
Well, I know he had a bus driving job. And I mean, I can get that information for you, the exact dates, but I'm going to say probably maybe 2 years, maybe he was employed with the Spalding County Board of Education.
Spalding, P-A-U-L-D-I-N-G.
P-A-U-L-D-I-N-G.
Just being careful.
I'm sorry.
No, it's okay.
That
Yeah.
is an important distinction in this case.
And so I don't know exactly really what happened with that because he was let go or got injured on the job, but
And
never really
after-
understood exactly what happened.
And after that, how was he making a living?
I mean, he would, you know, he was always working on a vehicle here and there
Okay,
for friends.
So he was
Family.
He was doing vehicle repairs, and was that out of y'all's property?
Yes.
Okay.
Yeah.
No further questions.
Okay.
All right, Mr. Campbell, you have the right to ask some questions here if you wish. I've given you a notepad so you could trace. I gave you a notepad when she began her testimony so that you could write down information you thought was relevant. Do you wish to ask her any questions?
Who do I ask questions to?
You can ask, y'all are not yet divorced, is that correct? The divorce is pending? Okay, so
he's my
estranged.
ex.
So, okay, for X, for all intents and purposes, you may ask her questions. You'll use your microphone. I've got you up here. You're not the witness. I've got her testifying, but I wanted to put you all at separate tables. And so that's why I've got you up here by me.
Sure, my hearing aid died a few minutes ago, though.
That's all right. I'm gonna get really loud. You ready? You're not testifying. I've got you here because I wasn't willing to put you and her at the same table. And so
Okay,
you're
I got
sitting,
you.
you're sitting at your own counsel table that just happens to be the witness seat, but you're not testifying.
Okay,
All right. Do you want to ask her any questions about what she just testified to?
that would be nice.
All right. Nice and slow and loud, and then I think this is all we're gonna need for this round. All right. Ask
So,
questions.
When did you find out there was a deed prepared transferring the property back to you and I? You said after I left the house.
Yes, that is when I found it in some
After I left,
Hold on,
documents.
she's answering. Hold on.
documents that was left behind.
they were left behind
copy?
after I moved to Florida.
Yes.
When did I move to Florida? Do you remember?
Probably around May 27th,
What date is Memorial Day? Does anybody know?
Nope.
Okay,
whatever that weekend was.
so
that's
you
when-
did not have the deed in your possession until Memorial Day?
I didn't know about it.
You did not?
No, you kept me in the dark about it.
I understand. I got a affidavit from Pauletta Owens.
No, this is asking her I mean, we can deal with that in a minute.
Okay.
Right now, this is just, do you have questions for her? Because her attorney has an appointment she needs to get to.
I understand. And so, it's your testimony that you did not get that deed until I left the property.
Yes.
Okay? Perfect. Thank you.
All right. Does anyone need Mandy Campbell or her attorney to stay for the next round that we'll do in a minute?
No, Your Honor.
You don't need them to stay, do you?
One more question.
Okay, let's get that out of the way so they can go. Go ahead.
Why did I lose the bus driving job?
I would like to know that. I would, because it's very funny that after you lost that job, I get a job and my wages are garnished.
Okay, thank you.
All right. Anything else from her before we cut those two loose?
No, thank you, Your Honor.
All right. Anything else, Mr. Campbell?
No, sir.
All right. That's all right. You may go back out into the gallery. You two are released. If Mr. Campbell, you stick around. Good luck at your next appointment.
What's that? I'm sorry.
Her attorney has an appointment she needs to get
Okay, I
to.
understand.
So that's why I broke it up into two pieces.
Okay,
It's gonna be Jesus.
I'll talk to my boss.
Yeah, I'll send you an email.
All right. So Mr. Campbell, you go grab a seat out there. I'm gonna come back to you in just a minute because I promised Miss Bando she could go next and they got a quick thing. Mr. Ryan, you're free to move about, and Mr. Webb, you're free to move about as you wish. All right. See you. I figured you were, but I was just trying to be careful. All right, so, all right, Ms. Bando, again, I appreciate your patience on that. Tell me your last name again.
Sure, God.
Sure got. I wrote that down, but my handwriting is horrific. That's why nobody lets me write on anything. Mr. Shergott, am I correct that you all would like this taken down?
That's correct.
All right, is that correct, Ms. Bando?
Yes, Your Honor.
All right, and y'all are splitting this. Okay.
Yeah.
Am I saying it correctly, Bando?
You are perfectly.
Because names are important, and I am well known for messing them up the first time. All right, well, Miss Bando, it's good to have you here virtually. Your audio is good and clear. If you ever can't hear to your own satisfaction, wave frantically, and I'll pause, and we'll get that fixed. All right, Ms. Shergo, anything else before we jump in?
No.
All right, any other housekeeping, Ms. Bando, before we jump in?
No, Your Honor.
All right, I believe you have the floor. I believe it's defendant's motion.
That's correct.
All right.
So plaintiff filed the instant action against defendant, Georgia Department of Public Health. I'm going to call them DPH for short, but if you need any clarification, please let me know. This was related to an October 21st, 2022 motor vehicle collision in which plaintiff was allegedly injured. This incident occurred on Georgia Highway 3 at its intersection with Vineyard Road in Spalding County, Georgia. And the complaint alleges that a Paul Walford was working for defendant DPH when this collision occurred. And so since this is a tort case being brought against an employee of a state agency, the Georgia Tort Claims Act, or the GTCA for short, governs this action, and the plaintiff has to strictly comply with the provisions of the Georgia Tort Claims Act. And the Tort Claims Act is the statutory scheme that provides for the state agencies limited waiver of sovereign immunity. And that's important because the plaintiff is the one that has the burden to show that a waiver of sovereign immunity has in fact been accomplished. If not, this court lacks subject matter jurisdiction, which is what our motion is arguing, that this court lacks both personal and subject matter jurisdiction. But I'm going to mostly stick to subject matter jurisdiction today. This case has a lot of issues as far as the Department of Public Health is concerned, and then the fact that the Department of Public Safety was being brought into this case. So since the filing of the motions in Fulton County, I just want to make clear some of the issues that have been resolved. Obviously, we are here now, not in Fulton County, so venue has been satisfied. There is a mailing of the complaint that's required under the Tort Claims Act to the Attorney General's office. That has been satisfied. And then attaching receipts to the complaint showing delivery of the ante-litem notice, which I'll get into in a minute, has been satisfied with respect to the Department of Public Health. The main issue with this case that is fatal to plaintiff's claim is that the plaintiff failed to state an amount of loss in the ante-litem or pre-suit notice, such that this action is barred against any Georgia state agency, which includes DPH and DPS. So before filing suit, a plaintiff has to provide pre-suit notice within 12 months in a specified manner. The notice, and that's 50-21-26. The notice must contain 6 pieces of information, and one of those is the amount of loss claimed, and that can be found in 50-21-26 A5E. And our argument is that the ante-litem notice in this case is insufficient because it did not have that amount of loss. Specifically, the ante-litem notice was sent on June 21st, 2023, and it states in paragraph 1, while our investigation is still ongoing, the specific dollar amount has yet to be determined in reference to the amount of loss. Now, this is directly analogous with the Georgia Supreme Court ruling in Board of Regents of the University System of Georgia versus Myers. And the site for that is 295 Georgia 843. That's a 2014 case. And I have a copy of it. You said you have Westlaw.
Yeah, I have it here. I just need to make certain I've typed it in correctly. We're good.
Okay.
Keep going.
And so The pre-suit notice in the Myers case said, quote, "The amount of loss is yet to be determined as she, Myers, is still incurring medical bills and does not know the full extent of the injury." And the trial court there held that Myers failed to entirely comply with the notice requirement. And the court's reasoning was the Tort Claims Act doesn't require you to provide the amount of the entire loss, but the amount of loss claimed at the time within the belief and knowledge of the claimant as may be practicable under the circumstances. Now, I don't know what they knew at the time as far as the amount of loss claimed, but it's clear that by failing to include an amount of loss in the ante litem notice, that is a failure to strictly comply with the pre-suit notice provisions of the Tort Claims Act. And so because of that, as I mentioned earlier, that's fatal to any claim that can be brought against DPH or DPS. And that alone should warrant dismissal. But there are a lot of other issues with this case. First of all, the DPH, and I'm going to start with the Department of Public Health issues because they're still a named party in this case. But they're immune from suit as they were an improper defendant. The Tort Claims Act provides that a state officer who commits a tort while acting within the scope of his or her official employment is not subject to lawsuit. Instead, the claimant must name as a party defendant only the state government entity for which the employee was acting for. Now, along with the first motion to dismiss that was filed on November 15th, 2024, we had an affidavit from Forrest Tennant, who is an employee of the Department of Public Health. And it essentially says that Paul Wofford, the alleged, the other driver who was allegedly involved in this incident, was never an employee of the Department of Public Health. So Department of Public Health is not a proper defendant in this case. The next issue is that the Department of Public Health wasn't properly served in this case. The governing statute for service of process against Georgia state agencies is 5021-35. And in addition to causing service to be served upon the director of the Risk Management Division of DOAS, the Department of Administrative Services. I know I'm throwing a lot of departments here, but to perfect service against the state agency, you need to serve it upon the director of the Risk Management Division of DOAS and the chief executive officer of the state government entity. There were no returns of service filed showing that the director of the Risk Management Division of the Department of Administrative Services was served within the statute of limitations. The return of service that was filed on the docket shows that they were served October 25th, 2024, 4 days beyond the statute of limitations. And the same applies switching to the Department of Public Safety. Because they didn't serve the risk management, the director of the Risk Management Division of DOAS, plaintiff lacks personal jurisdiction over them as well. The chief executive officer of DPS was not served until after the expiration of the statute of limitations, which was November 21st, 2024. But really, the suit against DPS should be barred in its whole. Plaintiff tried to amend their complaint to add DPS as a defendant after the statute of limitations, which expired on October 21st, 2024. And at that point, DPH had answered. And so under the I believe it's the relation back statute, but the plaintiff would have had to seek leave from the court to amend the complaint and add DPS as a party. And it's clear that they can't meet the conditions of relation back under Georgia law. Specifically, DPS had no notice of this lawsuit during the applicable limitation period and had no reason to believe that an action would be brought due to the lack of an ante litem notice. And Georgia courts have emphasized that the notice of the institution of the action, not just the incident, is the material inquiry. And that comes from St. Francis Health LLC versus Wang. That is 354 Georgia Appellate 310. It's a 2020 case.
Got it.
And so adding DPS to the case is not proper under the relation back statute. But there are Also deficiencies with the ante litem notice as it pertains to DPS. No person shall have a claim against the Georgia state agency without providing notice in writing in a timely manner. And so that was 12 months from the date of loss that plaintiff had to notify DPS through the proper, with the proper information that there was a claim that could possibly result in litigation. The only notice that we have, I believe, was filed along with plaintiff's response brief. I may be incorrect on that. It might have been the second amended complaint, but that was provided on November 20th, 2024, which is nearly 2 years after the date of loss, clearly beyond the 12 months required by the Tort Claims Act. With respect to that specific ante litem notice, the November 20th, 2024 ante litem notice, the ante litem notice statute 502126, specifically in provision B, requires that a claimant wait 90 days after the submission of the pre-suit notice, or that the claim is denied by the Department of Administrative Services before they can file suit. The ante litem notice, as I mentioned, was submitted on November 20th, 2024, and DPS was served on November 22nd, 2024. 2 days after is not 90 days, and there was no denial from DOAS. And then the last issue with respect to DPS. In addition to providing a pre-suit notice to the proper state agency, when a complaint is filed, you need to attach the ante litem notice to the complaint along with the receipts showing that it was delivered to the proper parties, specifically the Department of Administrative Services. We raised this issue, DPS did, in a special appearance motion to dismiss, I believe. We raised that issue on December 23rd, 2024. And Georgia law allows plaintiffs to cure that issue within 30 days, but plaintiff hasn't done so. So just another reason that DPS specifically, a claim or case cannot be brought against them. And I wanted to make sure that I get all of those bases on the record for you, Your Honor, but we don't even have to get past the first issue of the fact that the amount of loss was not included on the ante litem notice. And Georgia courts have overwhelmingly concluded that that's fatal to a claim. And so given the numerous reasons why this court lacks subject matter jurisdiction, we would respectfully request that our motion to dismiss is granted.
Okay. All right. Thank you, Mr. Shergo. Anything else before I pivot to Ms. Bando? Or Shergot, excuse me. Bando, Shergot. I got it.
You got it right.
All right.
Nothing at this time.
All right. Apologize for that. Ms. Bando, the floor is yours.
Yes, Your Honor. So I'll concede and won't belabor the point about the amount. It was not included in the ante litem notice. He was right. He quoted exactly correctly. The only issue, well, not even the only issue, but the main issue is that even if that's the case, plaintiff was never going to be able to comply with anything required in the statute in its detrimental reliance on the representations from the state of Georgia. So when the claim was filed and they sent the police report and everything that happened, the state themselves, the adjuster, I attached to the exhibit 1 to our response. They
Hold
actually.
on. Just pause. I just need you to slow down just a bit. There's an ever so slight delay, and I'm having a little trouble tracking. So if you'll just slow down a hair, I think you think that's gonna work, Kathy? If she just slows down. Yeah, so if you'll just slow down a little bit and do exactly what you're doing, slightly slower, we'll be fine.
Okay, understood. So attached to our responsive motion to their motion to dismiss is exhibit 1, where the state of Georgia identified the state agency that was responsible as the Department of Public Health. So throughout all of the time dealing with the state, waiting for them to accept or deny the claim, the state themselves represented that the Department of Public Health was the department that was involved in the tort that brought us here today. The first time that the defendant said anything about this being a wrong agency was in its motion to dismiss that was filed with the Fulton County Superior Court. So the main thing that we're saying is, like, their hands are not clean, and so they should be stopped from basically getting a windfall from, because it's their error saying that this is the agency, we relied on their representation, which is why that's the department that was sued. So they were the improper party because of the defendant's representations. As far as the service of process, after we were made aware that the improper defendant was a part of the lawsuit, we amended the complaint and had everybody served pursuant to the statute that governs this, which he referenced as the GT.
No, we lost you again. That's right.
Okay.
Last 15 seconds. Do that part again. You were starting about service.
Yes, and I was saying that once we were provided or placed on notice through their motion to dismiss that we had in fact named and served the wrong party, we amended the complaint and had everybody serve pursuant to the GTCA when we named the Department of Public Safety. And so we attached all these exhibits to our motion and also cited everything there. And that's pretty much all that we have.
Okay. And as you've referenced each of these documents, I've been looking at the documents you're referencing on my screen. So I'm just letting you know that I'm as y'all are referencing these things, I'm both tagging the cases, tagging the statutes, and referencing the documents. Anything else, Ms. Spando, before I pivot back to defense?
No, Your Honor.
All right. The floor is yours.
Plaintiff, the opposing counsel's concession that the amount of loss is not included on the anti litem notice is enough for this case to get dismissed. I understand that there was some person at DOAS, the adjuster rather, that stated that it was the Department of Public Health. But as I mentioned earlier, the appellate courts of Georgia have repeatedly stated that substantial compliance is not sufficient, that strict compliance applies regardless. And so the fact that there was some belief that it was the Department of Public Health as opposed to the Department of Public Safety is really not relevant to the issue of whether this court has subject matter jurisdiction, given the fact that the anti litem notice was deficient in the first place.
Okay. And again, this was well briefed. I mean, you, as y'all have already referenced, on the defense side, you said that the first one is foundational, but then you very kindly went through each of the others behind it. And I appreciate that detailed level of briefing. And for Ms. Bando, I'm very grateful that each of these things that you're saying were important for you, such as the misidentification of the of the agency where the individual worked. Y'all have included all of those in there. So it's very nice as a judge to be in the presence of, frankly, good lawyers doing a good job with their people and looking out for them. So, all right. Anything else before I pivot back to Ms. Bando to respond? All right, Ms. Bando, do you wish to respond to anything else in this so far?
No, Your Honor. As you mentioned, it's already been briefed.
Yes. And like I said, y'all did a really good job with that. And I was just impressed with y'all in person as I was with y'all in your briefings. So, okay. Let me see. So if y'all don't have anything else, I'm going to do my standard proposed orders request. If you all could take your motions and convert them into proposed orders, 30 days, does that work for y'all?
Works for me.
Yes, Your Honor.
Okay. So I think we already figured out that 30 days does fall on a weekday. Today's the 10th, so October 10th. October 10th is a Friday. So I'm going to put under advisement proposed orders 10/10. Okay. Ms. Bando, is there anything else from the plaintiff that I can address before we cut you loose virtually?
No, Your Honor. That's all. Thank you.
All right. Anything else? All right. You heading back to Atlanta?
Yes, sir.
All right. Well, Ms. Bando, you have a safe travels wherever you're heading to, or if you're home, have a safe disconnection from the virtual system. And I hope you have a safe drive.
Thank you, Your Honor.
All right. Y'all are both released. Thank you so much. Okay. Mr. Webb, you may resume your seat. Mr. Campbell, you can come back up and you can have the table now. So bring all your stuff back up, and this will be your table. And Kathy, the lawyers today, Clint
You're not
gathered
gonna be impressed
cards
with
and
this
everything.
attorney,
So we
I'm
have
sure.
cards, we have all kinds of good stuff. I'm sorry?
You was impressed with those attorneys, you're not gonna be impressed with this one.
That's all right. That is my job, is to make certain that everybody gets a fair pathway through it, and we're gonna make sure we do this. And let's face it, you and I have been doing this a good several years now, so this is just
Almost
the.
eight.
Almost
Coming
eight,
up
so-
on an anniversary.
Yes, so, yeah, the fact that you and I have an anniversary is, let's get you closed and get me in your rearview mirror,
Let's
okay?
get this solved.
All right.
Yeah.
All right, then what we're gonna do is, so we dealt with just a minute ago, we needed to break it up. We don't normally do that, Mr. Campbell, but we
It's
had
fine.
to break it up. And so, what we're gonna do is, because you're telling me you're having trouble with your hearing aids, I'm gonna get real close like this. Does that work for you?
Yes, sir.
Okay. If you ever can't hear, you just wave at me and we'll stop, and whoever's talking, we'll get them to be louder. Will that work for you?
Yes, sir.
All right. So, Mr. Webb, obviously you're already good at this, but just be nice and loud.
Yes, Your Honor.
All right. And then Kathy, obviously, if you have any trouble, let us know. All right. So, Mr. Campbell, do you have any questions for me about what we're doing or what we're about to do that I can clarify for you or make certain that you feel like you understand what's happening? Any questions at all?
I don't really know, but we'll do what we gotta do.
Okay. Well, what we're about to do is we dealt with your ex-wife's or soon-to-be ex-wife's portion first because her attorney had to go. And so she worked out an agreement, remember, with Mr. Webb, and we put those terms on.
Sure.
And that was not a decision I made. Did you catch that? That I didn't make any decision there. They just reached an agreement.
Sure.
Okay. Well, now we're dealing with your side of the case.
Okay.
And so Mr. Webb has brought you here today so that we can deal with his request for this contempt hearing.
Sure.
Okay. And then if you have questions, we'll address them as we go.
Okay.
All right, we're ready. Mr. Webb, the floor is yours.
Thank you, Judge. Before we launch into my motion for contempt, I do believe from our conversation in the hallway that Mr. Campbell agrees to the revival of the initial judgment, the scary fascist, to assist with this. Is that accurate? Did you understand what I just said?
He's having difficulty. All right. You understand that there's an older case, that there's an older filing, and they're trying to bring it back up.
Sure.
Are you okay with that?
I'm not.
You're not. Okay. Which is what I thought was going to happen. So that's okay, but that is what I thought was going to
I'm
happen.
sure we can work it out somehow.
Right. But if you're okay with it, then that means that you two have worked it out. If you're not okay with it, that's okay. It just means I have to decide whether or not to allow him to bring back this older case back to life. Do you understand that?
That's the judgment.
That's correct. And do you understand he's trying to bring it back?
Okay.
Are you objecting to him bringing it back?
Well, I got a few reasons I object to it.
Then now we're going somewhere.
All right.
I think we have our framework for that point. Is it good?
Yes, Judge.
All right, floor is yours.
Okay. Are we addressing the scary fascists and then the motion? Okay. So, by statute, within 3 years, you can revive a dormant judgment. In this case, the FIFA was issued in August of 2017, and unfortunately, I didn't catch that prior to the 7 years. And because we were doing collections up in Spalding County and filing things up there on the FIFA there, it was just an oversight on my part. Mr. Campbell's mother was good enough to point that out to me. And so I immediately filed the petition for scary fascists. And this is as to the initial judgment. So as the court will, I'm sure, recall, we had a judgment entered on the underlying principal liability, and we had a trial set for the punitive damages in this case for a jury, at which point Mr. Campbell's attorney showed up and settled, just as to him, his punitive damages liability, and then the Campbells filed bankruptcy. Then there was a delay for some time there. And of course, a lot of what we're here about on the motion for contempt has to do with the deed that they executed transferring their residence over to Mr. Campbell's mother right before the bankruptcy case was resolved with an order stating that it was non-dischargeable because the judgment arose from fraud. But due to the settlement with Mr. Campbell's attorney, his liability was capped at $33,000 when the bankruptcy court ruled that it was non-dischargeable. And by that I mean his liability on the punitive damages, not the underlying judgment. Well, then we went up to Spalding County and filed a motion to set aside this deed as void under multiple theories. And I have a terrible opinion now of the bench in Spalding County because the treatment that we got up there was unconscionable and completely inappropriate. And I fully intend to file a complaint against the judge who handled that once this is all resolved. I mean, you all are familiar with the term home cooked. I mean, I was roasted, stewed, and served up on a platter. They filed in a notice of a hearing and did not send it to my office and dismissed the case at one point. I pointed out to them that they had not served a notice to my office, and then they revived that case. But by then I had filed another one because I had to keep the Liz Pendens in place. And then they started messing around with me about a prior existing lawsuit. Judge Bauchi sanctioned me for discovery violations because I responded to a 6.4 letter with another 6.4 letter and said, here's a bunch of stuff. If it's not good enough, let me know. They file a motion. And then the only time I've ever been sanctioned for anything in my decade-long career, this court up there is just, it was insane, right? And so this goes on for years. And this entire time, the Campbell's counsel is defending this and playing all kinds of games. And, you know, as the court knows, I then, during this time, did experience some traumatic brain injury. And then I was filing these things up with the Spalding County Superior Court. The original judgment for $86,000 went dormant, and we filed a motion to revive it. The judgment in FIFA for the punitive damages is still in place, and the FIFA is still alive. Now that this deed has been entered and clear title exists in the Campbells, we can foreclose on that property, but I don't have a valid FIFA on the initial $86,000 judgment. So we followed the procedure for the scary fascists under 9/1263. Mr. Campbell was served with this. He was very evasive. He ran to Florida. He told the deputies down there he was living in Alabama. He was coming up for cancer. I literally had my one of my process servers, who this court is familiar with, Daniel English, who it pops up from time to time, and we have the judgment debtors who are very evasive, former combat Marine, and he's really good at following through. But he coordinated with the sheriff's department down there. They tracked Mr. Campbell's plates, and ultimately they were able to figure out where he was and get him served. And so he did have proper notice of this petition. Mandy Campbell has consented, and all statutory requirements have been met. They have not objected and demanded a jury trial. I do believe the time for that has passed, and therefore, the appropriate thing is to enter the order reviving the judgment.
Okay, thank you. Mr. Campbell, you said you had a few objections to me bringing that old judgment forward and back into active status.
Yes,
Is that correct?
yes, sir.
What are those objections?
Okay, so if you go way back, I owned a shop in Griffin. I liquidated that shop. He could have easily got the money then, and I would have happily give it to him. I don't quarrel that I owe the folks a debt. Don't
Your
quar-
Honor, can we swear him in, because there's some factual
Yeah, that's a good point.
testimony going on.
Raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give is to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Are the statements you've already made so far through this whole thing true and correct?
Okay, yes, sir.
Yes,
I own a
okay,
piece
yes.
of property. My original attorney entered into an agreement I didn't even know about. I didn't even know anything Walter done. He got this board, you know about that one. That was a mess.
I had a front row seat to this
Yeah.
case and that event and
And the
all
thing,
of it.
I mean, that was a goobered up mess. And the thing about it was that boy kept getting a paycheck from me every month for that next 18 months while he wasn't even a lawyer. But that doesn't matter. You know, he does what he does. So Mr. Webb, he had all that time, he could have got the money way back then. He didn't do it. Okay? Secondly, he knew I drove a school bus. I got hurt on the job, had to have shoulder surgery. They can't have me back. He could have garnished my wages at that point. Now, we did file bankruptcy. I have an affidavit from my mother explaining about the deed. So I got cancer. I got the cancer fixed, but now the cancer has come back. I'm choosing not to.
You're good. Just slow down. I'm having trouble keeping up with you, and I'm
Okay.
worried Kathy is as well. So
I'm sorry.
You're good. Just
So-
Mr. Webb, will you pull that the lectern back just a little bit? I think it's in Kathy's line of sight.
Happy to.
Yeah, I could see Kathy having to lean this way to see you.
I got the cancer.
Okay, slow down and keep going.
I got the cancer. And I got that part fixed, but the cancer come back. I personally am choosing not to fight it this time. Okay?
I'm
So-
really sorry for that. by
No,
the way.
it's fine. Don't
I
be
know.
sorry.
Just
But listen.
Don't you hear me say I'm
So
sorry?
this deed thing, my mother prepared that deed to protect my wife, and it was not supposed to be filed until I died or my mother died. Letitia got the deed when I was sick out of my box. Her attorney and her sat right here and lied to you, and the simple fact I can prove they lied to you, I can't prove it right this minute, but I didn't know I was prepared to do that, is they had the deed before they filed for divorce from me. Okay? So they had that deed, and here's the affidavit from my mom explaining what that deed was for. So he thinks I tried to hoodoo him about the deed. I did not. If I kicked the bucket, my mom was supposed to make sure Letitia got that house. I want Letitia to have that house. Okay, simple as that. I don't know how she gonna get it, but and I don't know how I'm gonna get them folks paid, and I do want to pay them. But that 80,000 thing, he's had ample opportunity to go get it. Also, he talked about all them lawsuits. He said a minute ago, he said it was his oversight. This is not my oversight. He the one that screwed this up. He could have filed this stuff. All right, let me tell you something else. So he sued my mama, and guess what he didn't do? He talking about all these people being bad to him. Okay, he just said this is oversight on my fault that I didn't renew this lien. Let me tell you what else. He never deposed my mama. He gets upset, so now he just filed a whole new lawsuit in federal court so he gets the opportunity to depose my mama. He deposed my mama, and she gonna tell him, hey, I prepared that deed to protect my daughter-in-law. Okay, these folks get hating on me, that's all good. I want them to have that house. This is nothing but vindictive and spitefulness.
May I suggest that he tender that affidavit?
Yes.
Absolutely,
And
I
we
can do
will-
that.
We do not object.
Okay. Hand it to the bailiffs. Let them make a couple of copies.
There are 3 copies there. One of them is the original. I made 3 copies. I didn't know what I was supposed to do. Okay? So, then, he could have put a lien on the shop building I own. Okay? He could have put a lien on my bus driving salary. okay? Now, just because Mandy changed her mind that she don't want to be married to me no more, that's all good and well, but don't sit up here and lie about when you got deeds out of these boxes, okay? He talking about another court being home cooked against him. Man, I don't know nothing about that. If they don't like him, hell, I don't like him. I don't know why anybody'd like him to start with. If they don't like him up there, I can't help that. They don't like me either.
Well, the fact is that this court's responsibility is to make certain that everybody who comes through
Sure.
here, whether they're likable or not, gets a fair shake on a fair field.
Well, if
So
he
let's get back to that question.
Yeah, he dropped the ball on this, and I don't see where he should get it renewed if it's his fault that he dropped the ball. I didn't drop the ball. I've tried to offer this guy money all along. In fact, the attorney, Matthew, he is tip top. Matthew had marching orders to try to give him $110,000, and he wouldn't even entertain it. And I thought that was more than fair. I authorized Matthew to go to $110,000. And he wouldn't even do it. And look, this whole thing started over a $10,000 car, and now he tell me in the hallway it's up to $400,000. I don't. The $33,000 I understand survives. Give him the $33,000. They only got a $10,000 car. $33,000. That's more than 3 times what it ended up to start out to be.
All right.
So I don't know if any of that makes any sense. I ain't
No,
an attorney.
I'm tracking 100%. So, I mean, I remember your case like it was yesterday.
Yeah.
I remember Walter Moore's situation where he got disbarred like it was yesterday. Like, I didn't have to do a lot of work to get ready for these hearings because
Yeah.
I've never forgotten any of it.
And I'm sorry you had to go through that.
It's all right. I love my job. All right. So here's what we need to do. The bailiffs are copying that affidavit. They're going to give a copy to Mr. Webb, copy to me, and then they're going to give you back your originals.
And I'm sorry I wasn't all proper, but I can't hardly hear myself even talk.
We have lots of folks who come through who can't hear. What's important is that when all's said and done, you feel like you can hear me.
Sure.
And that if you can't, you stop me and say, I
Sure.
can't hear you.
Sure, and I know you got to make decisions, and I respect that decision.
Okay, thank you for that. Mr. Webb, let's just hit the dates on the judgment, the dormancy, and the steps you took to get it back. And that's all I need to finish up this round of what we're going to do.
Got more?
So hold on, Mr. Webb's going to give us some dates. I got him here. I want to make certain that his dates and the court's dates line up.
Okie doke.
All right, so, Fife entered August 29th, 2017. And the petition to revive it for Scary Fascists was filed July 15th, 2025. And so that was less than a year after it went dormant, well within the 3 years required.
Okay.
I think those are the relevant dates.
There. All right. Mr. Campbell, what Mr. Webb just said is, and the law has a fancy name for this because lawyers love fancy names with $5 legal words. So he keeps saying the word scary facies, which is the correct term for what we're dealing with. What it really means is that more than 7 years have passed since a judgment was issued and it was not renewed, which requires them to take some steps. And as you've said, and he's already acknowledged, he missed that 7-year window. The law provides him a 3-year window to fix it, and a year in, and we're within those 3 years. Excuse me. I had to get my words in my head straight. And so if he has taken those actions within the 3 years to bring this case, to bring the judgment back alive, the law says that I am supposed to review that and make that decision unless there's something out there that says he shouldn't have it. I'm supposed to go forward with this.
I get it.
And I have not heard anything that says he shouldn't be able to bring it back.
It doesn't surprise me.
I know. I'm trying to be really clear with you about what the law says I'm supposed to use in making my decisions. And the law says that the information I have over here and the information he's put on the record, there's nothing that I've heard that says I'm not supposed to, which means I'm supposed to.
I
So-
get it, it's fine.
Okay, all right, so again, doesn't matter whether anybody's likable or not likable, he's checked the boxes he needs to check to bring it back. So, sorry, but
No,
this,
it's fine.
this round goes to them.
Oh, good,
So-
it's fine.
Okay.
I get it.
All right, then you may draw an order, Mr. Webb,
Thank you, Judge.
reviving your judgment. All right, do I need to deal with this motion for publication? I assume since he's sitting here.
No, Judge.
Okay, all right. Do you need him to- Okay, just file a withdrawal of that. That way I can close that motion, the motion for publication. Yeah, so just a notice of withdrawal. So that'll
Yes, Judge.
close that loop. All right, what's next, Mr. Webb?
Our motion for contempt.
All right. So you understand, Mr. Campbell, we're moving. Remember, we had two cases we were dealing with. The 25 SV 387 was that fancy $5 legal word to bring the judgment back, which was, of course, based off of your 15 SV 225. That was our original case we had together when I first took the bench.
I trust you.
So-
It's
Well, it's my job to make certain you hear it. And then now we're moving over to, nope, wrong page. Now we're moving over to 22 SV 288. That's the case where Mr. Webb is asking me to hold you in contempt. Now, he's not asking me to lock you up.
That's what I only thought I was coming up here for that one.
Well, and we're coming here for both. So,
It's okay.
all right, Mr. Webb, floor is yours.
All right, so, Judge, we've been here so many times on motions to compel, discovery in this case, both during the initial lawsuit and then in post-judgment discovery. And through it all, James Campbell has maintained that title to his house was in his mother's name. And he just sat here and told you that he and his mother executed a deed back to Mandy Campbell in 2020. He said, and I mean, it was to himself as well, which doesn't quite align with what he's saying, but he's admitting that the purpose of this deed, which was entered, and it's my understanding he's not contesting the deed exists or why it was entered, was to ensure that Mandy Campbell received this property. Now, that deed is certainly responsive to the post-judgment discovery in this case, which is covered by our multiple motions to compel, by the deposition testimony that was given by the parties. And Your Honor, I lay out the specific discovery requests specifically and the specific responses in my brief, as well as the deposition testimony that was elicited, all of which were false statements. But I'll just, for the record, just very briefly go over the specific requests, but I won't read them out aloud unless the court needs me to. Okay. Interrogatory 11, it asked about real property in which Mr. Campbell held an interest, and he stated that none exists. Interrogatory 13 asked to list property, including real property, held by any other person for his benefit or Mandy Campbell's benefit, and said none exists. 14 asks about real property which is held for your benefit, but is not currently owned by you. Said none exists. And then there's requests for production that cover it as well. Request for production 2 asks about documentation of property. Number 4 asks about warranty deeds and quitclaim deeds. This is certainly covered by that. It is a quitclaim deed. Request for protection 5 asks for deeds. Again, from 2017 to present, this 2020 deed was certainly within that time frame. None exists. Number 6 asks about encumbrance or transfer of real property. That's certainly covered. None exists. Request for protection 7. Again, transfer of real property. So none exists. And then in his sworn deposition testimony, James Campbell repeatedly denied ownership of the property. And he stated, for instance, at page 27, lines 5 through 8, when talking about his compensation for working on the house, he states that his compensation was he gets to stay there until his mother decides to sell it. But she can't sell it because it's all tied up. Now that completely contradicts what he just told the court today. It also happens to be completely false because there was a deed transferring title back to James and Mandy Campbell. And then he states also at page 16 of his deposition that they were describing this purported agreement between him and his mother was that she was going to build a house. I'm going to oversee it. If I'm able, I'll buy it. If not, then I got to hit the road. Of course, this is completely inaccurate because he held a title to that house at the time he was making that testimony. We went through a 2-year process of me trying to do discovery about this transaction. I had to dismiss the Spalding County case because that judge said he was going to sanction me for asking these questions in discovery. It was ridiculous, and that's why we're in a federal lawsuit now, because I had to go to federal court where at least they follow the rules of evidence and civil procedure. But through all this, through this repeated lying and obstruction of this lawsuit, and through to today, for this motion, our attorney's fees that directly result from these false discovery responses have reached the amount of $250,000 in costs and time. Hearings, discovery, more hearings, dealing with kangaroo court procedures, having to file in federal court, all this stuff. And, you know, Rule 37 is pretty clear. A trial court clearly has discretion to impose Rule 37D sanctions if it finds the offending party has provided discovery responses which were false or deliberately misleading. This is both, obviously. And I cited the court in my brief to some case law as well, such as Resurgence v. Elliott. It's a 2017 case. It can be found at page 7 of the brief, where the Supreme Court of Georgia says, where a party has provided false or intentionally misleading responses to written discovery, the aggrieved party may seek sanctions for the same. That is what we have here. It is very clearly within this court's power to punish this behavior. So when we look at remedies, we're looking at 37D, B2A, and B2C. We are seeking civil contempt here because the primary damage done by this misleading, deceptive discovery is just to cause us to have to spin our wheels for years and spend a lot of my firm's resources. Obviously, if they disclosed this deed, we wouldn't have pursued avoidable transfer case, or the second one that we had to file when they dismissed the first one for no reason, or the federal one is still pending, which I will point out that his mother has denied the existence of this deed in that case, which is just insane, right? Because here she has an affidavit saying that she signed it. So obviously that's why I wanted it filed in, so I can file it into the federal case. But the point is that the language states the court is empowered to award all fees that were made necessary by false responses, and that's what we have here. And therefore, all of our reasonable and necessary costs and fees of $250,000 to date are recoverable and should be awarded against Mr. Campbell. Now, we have itemized fees for the court as of the filing of this back in July, and then that difference is what has accrued to today. And so I'm just gonna ask if the court has any further questions of me, and then I will turn it over to Mr. Campbell.
Not at this time.
All right, thank you.
Actually, I'm going to take that back. So if I do what you want me to do today, what exactly would I do?
You would order Mr. Campbell to provide full and accurate responses to the discovery, which, we just heard testimony from his wife that he just filed another deed transferring property to his mom. But anyway, so respond to the discovery and awarding $250,000 in costs and attorney's fees for his discovery violations.
And do you have that? You have that as a detailed, the 250 as a broken out?
The 213,000 as of July is broken out in detail.
That's fine.
And I'm telling you the difference through today with my time here. I'm including my drive back in that calculation.
Okay, that makes sense. Okay. But as of now, and as we stated, as we exchanged emails before, that jail is not on the table.
Well, technically, you have the power to incarcerate Mr. Campbell. I don't think that would necessarily be productive. And especially for me, I don't want that to happen, because if you do that, that counts as criminal contempt and you're limited to $500.
Yeah.
And I hope you don't do that.
Okay. And again, I'm just putting that on the record, Mr. Campbell, to make certain it's clear to you, Mr. Campbell, that, as I said earlier, that jail is not on the table for today. I'm just being very careful and clear, because you're not represented by an attorney. Your attorney would know that automatically. I'm just being careful. So.
Am I going to jail or no?
No.
Oh,
I'm
if
trying
I
to
go
tell you
jail, I gotta go get my medicine.
You're not going to jail. I'm just trying to I'm trying to tell you things that your attorney would know automatically. And obviously I can tell that between your hearing aid difficulty, I should slow down a little bit. Hey, you're not going to jail today.
Well, I guess that's a good thing.
There we go. We've checked that box. I was just checking that box because I have to say things out loud so that Miss Kathy can take them down, so that there's a record of it. And a lot of the things I have to say are awkward. And so I had to say that awkward thing out loud. Okay? All right.
Well, thank you.
Mr. Webb is saying that what he wants from you is full and accurate responses to all of his outstanding questions for discovery. I'm telling you what he just asked me for, because I was worried you might not have heard all of it. And so he also has detailed records for the efforts that he has taken, according to what he's saying. I'm just repeating what he's saying, for the time and the resources that he's saying he used to track you down and to try to find your assets. And he's asking for $250,000. He's saying of the 250, he's saying 213 has detailed notes next to it, and the rest of it is the distance between when he printed it and the work he's done now. I'm simply telling you these things as a courtesy. And then I wrote down jail is not on the table for today. Did I miss anything, Mr.
Is there
Webb?
gonna be another day to be on the table?
I hope not.
Me too.
I hope not. So, but we're gonna find that out here in just a little bit because I'm ready to shut all this down.
Let's get this stuff done.
So we've been doing this a long time, and I'm ready to be finished with it. All right. Anything else?
No, Judge, the deed is Exhibit 7. It's recorded with the court.
Yes. And I did not end up with a copy, but I'm sure there's a copy.
I'm happy to.
Well, I know John's got it in his hand over here. Thanks,
Yeah,
John.
I mean, there's just.
Let's go off record and let Kathy sort that out. So everybody stop talking for a second. Do what? It's defendants. Mr. Campbell held it up and said he had it for today's hearing. But hold on. All right, you're all clear? All right. So, this statement from, this is the one that Mr. Campbell referenced when he was sitting over here in the witness seat next to me. And I said, hold on a minute, we're going to do that part next. And I've got it in my hand. It's marked as Defense Exhibit 1 by Kathy, and it's officially tendered and admitted. Okay? We're good to go. You have a copy, and he has the original. I have a copy. All right. Anything else, Mr.
I suppose to perfect the record, we should ask Mr. Campbell about the deed.
Yes, that was part of what I had on my list.
Right.
Mr. Campbell, do you have any questions so far about what we've covered or what we've talked about? I can see your gears turning. It's okay. Take a minute, let your gears turn, and see if you have
Who
any.
did I ask the question to?
Me, I'm saying,
Oh.
do you have any questions for me?
No, I understand what's going on.
Okay. What's about to happen next is that Mr. Webb is going to ask you a few questions about some of these things that he's looking for information on.
Sure.
And I'm just going to ask you to answer it nice and slow and loud so that Miss Kathy can get it down. You understand that's what we're about to do next?
Yes, sir.
All right. Mr. Webb, you may ask your questions.
Mr. Campbell, can you hear me okay like this?
Yep.
All right, great. So it's my understanding that from what you said earlier, that this deed dated September 21st, 2020 was entered into by you and your mother on that date. Is that
No.
true? Okay, when was this deed entered?
She did that deed on her own. I never got it until I got sick. Letitia and I went to Florida, and my mom handed it to it then.
And when was that?
Been about 18 months ago.
Mr. Webb, can we just start at the basics? Because I need to update all my contact information for him.
Okay. Mr. Campbell, the court has just requested that we update your contact information. Can you please state where you currently reside?
348 Mercedes Avenue in Panama City,
All right. What's your birthday?
January 3rd, 1967.
1967?
Yes, sir.
Okay. All right. Last four of the social, not the whole thing, just the last four.
6534.
6534. I
Yeah.
have everything I need. Mr. Webb, you may continue.
Okay. Now, the affidavit you brought in from your mother states that as part of her estate plan, she directed the quitclaim deed be made, signed, and delivered to you, right?
You got, yes, sir. Yeah.
Okay. And that was done in September of 2020.
That was done for me to come up here. That piece of paper, is that what we're talking about?
This affidavit that you brought.
That was done for me
Okay.
to come up here today.
So, again, to be clear, this was entered, you stated, to ensure that the house went to Mandy Campbell when you and your mother passed?
No, sir.
Okay.
My mom did that So that my brother and sister wouldn't try to get something that should go to Mandy or me in her estate planning stuff. She prepared that deed to do that.
And why should the property go to you and Mandy?
Because we were married.
Okay. Is it because it was your property?
No, sir. That was my
Okay.
mom's property, and I guess that she wanted us to have it if she died. That'd be my guess. You'd have to ask somebody that knows more about that than I do.
I have a lot of James Campbells with different middle names. What's your middle name?
William,
William. Okay, that makes sense. Got it. Thumbs up.
When did you obtain title to 348 Mercedes Avenue?
I didn't, and I don't. It is still in my mom's name.
So you did not record a security deed this year transferring your interest in 348 Mercedes Avenue?
Absolutely not.
So why would Mandy have said that you sent her the security deed?
Don't know. You'd have to ask her.
Okay. Did you make money working on cars since 2017?
I don't believe so.
Okay. I've got nothing further, Your Honor.
Okay. Anything else, Mr. Campbell, that you want? Normally, at this moment, I'd look at your attorney and I would say, anything else you want to put on the record or ask your client? And you obviously don't have an attorney at this moment, so do you want to put anything else on the record as we start to wrap this up?
I do have some notes
Okay.
that I wrote down.
If you would like to, you can.
Okay, so it seems like this deed thing, he thinks I did it, but I didn't. What my mom did to prepare for her death or whatever she going through some tough stuff too. If she prepared the deed, whatever, when she passed this thing off to me and Mandy, is when I didn't know I was gonna be here. And she passed that deed off then. I didn't know she had prepared that thing in 2020. That's her business. That's her estate planning. That's not my estate planning. Okay? Now, Mr. Webb met the windows on these on these cases, when he filed these cases. He could have deposed Pauletta, and Pauletta would have said, yeah, I prepared that deed in 2020. But I can tell you, James Campbell and Letitia Campbell did not know about it until I got the cancer. And then my mom said, all right, here's what's going to happen. You take this deed. One of us died. You go record this deed. That's the first time we heard of it. And that is after that us receiving that deed from Pauletta is after he deposed me, and I had no knowledge of that deed ever existing. So he's saying, well, I asked James them questions. Did somebody holding something for you? Man, I didn't know about that. That's my mom's estate. That's not mine. You see what I'm saying? Did that make sense?
I'm following.
Okay, so what she did to prepare for her death, that's not on me. Okay, now if she did something to give it to me and Letitia, that's wonderful. That's great. And in this divorce, I just assumed Letitia had it. I got no need for it. That's the way I feel about it. Okay? And I told Letitia that when the divorce started. I have intention for you to keep this out. I thought I could get this thing with him settled before the divorce even got done. I had full intention to that. But anyway, then, I can't hardly read my writing.
That's all right. Take a deep breath. And just let me know when you got
I
it.
already said about Mom's action to prepare that deed that I didn't know nothing about. He could have deposed Pauletta. He didn't. He met his window of opportunity several times. I don't know why he did. You think, the court be mean to him, but he'd probably keep it tight of your ship at home. He'd probably get his stuff in order, Of course, I ain't one to say that. I've messed up enough stuff. I think he's being a little vindictive and spiteful in this whole thing. He looked at me and smirked a minute ago. That wasn't very nice. Okay, so the original case is done. He can attach that lien to this house, can't he? and then we figure out how to get that paid. I guess that was the question. I'm not sure.
All right. So you're one, now as far as the getting the stuff paid, that's not part, my part is to sort out the legal side of these
Okay.
questions.
I'd like to get the man paid, but 400,000, man, that's out of the question. And that extra 250, I don't know where you're gonna think you're gonna get that from, but I ain't got it. So, I think this, let him get his thing where he can go get his money. But this additional 250,000, he gonna dig my bones up and get my ring off, I reckon, 'cause that's all I'm gonna have. I think it's foolish to try to get that kind of money. That's just what I think, but, and again, I don't know a whole lot about that stuff.
Well, and again, I think a good way for you to think of me and my role in this as my job is to, and it's a terrible analogy, but it's the best bad one I've got in my head. I'm kind of the manufacturer's suggested retail price. My job is to say what it is. What are the things as they are legally standing as they're supposed to be?
Oh, I
And
think
then
you
if
do a
y'all
fine
want to,
job.
and
You
if
don't
y'all
have-
want to talk internally about resolving it, that's y'all's business. My job is to make decisions as to what it is.
I get it.
Okay.
I think you do a fine job. I got no quarrel with any of that.
Well, and again, I just want to get me in your rearview mirror, and I want you to be able to go live the rest of your days without wondering when I'm going to be looking for you.
Yeah,
again.
let's don't do this.
Yeah, that's right. So, okay. Do you have any other questions for me?
I don't. Probably think of 100 when I get in the truck and head home.
Okay. Well, I just need to remind you that you and I are now fully engaged again.
Oh, let me
Okay?
ask you a question.
You understand that we're fully engaged again. You're with me now.
I do have a question.
You understand what I just said?
I think so.
What I need you to understand is that from this moment forward, I'm keeping you under the responsibility of this court until we get this resolved.
Yes, sir.
We're not going to have a whole lot of more delays and all that. We're going to figure this out. We're going to get this done.
I'd like that.
All right, go ahead.
Okay, so I sent you a letter after I do it on Doom. Can I do that?
As soon as I knew you were engaged, I'm more willing to do that. But the fact is that we've been doing this for 8 years. I really wanted you to sit eyeball to eyeball with me while we sort out this, and you understand that I really need you to fully engage in this process and get this thing closed.
Yeah, I just ain't
So-
got no money to give you, that's all.
I get that issue, but remember, what you two work out with the money is the issue. My job is to call balls and strikes, call it what it is, whatever you want to say, whatever analogy you want to use. So, but yeah, I'm okay with us talking about you reporting virtually as long as I feel like you're fully engaged and paying attention to me.
Absolutely.
But I didn't know if you were or you weren't until I got you here for us to have this conversation.
Absolutely, I get it.
Okay, we can talk, if we have to do another hearing, we can talk about virtual at that time, and I will make a decision at that time. But I'll go ahead and tell you, it is my hope that we don't have another hearing.
Yeah, let's don't.
Yeah, I like that idea. All right, anything else?
No, let's just get this thing done.
All right, Mr. Webb?
Yeah, I gotta ask him about this security deed.
Okay, go ahead.
And could I ask the court to print this, actually?
The short answer is yes. I had to disconnect my printer from here yesterday. If you'll just email it to myself.
I can look on the computer if that helps.
Well, we'll print a copy for everybody. So that way you'll have a copy when you leave. So if you'll just email it to myself and Mr. Hope, we'll get it printed. Sorry, put John's. Yeah, you can email it. You gonna email it to us?
Yes.
If you hit print, does the printer come up for you?
Let's see.
Let's go off record. Okay, we have the paperwork, and we are back on record. Mr. Campbell did have a question. So did you write your question down?
I did, but it doesn't matter now because I think I answered it and I think we're all confused about something.
Okay, well then let's let Mr. Webb ask some questions, and then if you still think it's confusing after that, you can tell
I
me
think
after
all
that.
three of us are confused.
That's fine. Let's let Mr. Webb ask the questions, and then I think we'll sort that out.
All right. Okay for me to approach? the
Yes.
defense? Okay. I'm handing you, it's been marked as plaintiff's exhibit 1. Do you recognize that?
I do, yes, sir.
All right, what is it?
It is a deed transferring the property from my mother to myself. And if that's the one you were talking about a while ago, I misled you, and I'm sorry.
All right. Do you mind if I grab the copy?
Yeah, do whatever you need.
Got the copy now that I had. All right, so that's your signature
Yes,
at the
sir.
bottom?
Yes, sir.
Okay. And you entered this on July 7th, 2025?
Yes, sir.
And you had it recorded on July 18th, 2025?
Yes, sir.
All right. And it states that your mother paid you $94,000. Is that accurate?
No, sir.
Okay. Did you pay her $94,000?
No, sir.
Okay. And it says that you sell and convey to Pauletta Owens, 348 Mercedes Avenue, Panama City, Florida. Is that accurate?
Wait a minute, this ain't, no. No, sir. That's not what this is.
Who is the Cohen Law Office?
Who's what now?
The Cohen Law Office.
Cohen Law Office.
Okay. Did you ask an attorney to prepare this deed?
Elizabeth O. Williams, hold on a second, give me just 2 seconds. Elizabeth O. Williams prepared this.
And if I told you Elizabeth Williams is listed on the website for the Cohen Law Office, would that?
She's just a personal friend. I just used her, I told her to do this.
Okay. So she prepared this deed and you signed it and recorded it?
Yes. Actually, Elizabeth recorded it for me.
Okay. If I told you that the Bay County tax assessor has you recorded as the title owner of this property, would that surprise you?
Yes.
Why would that surprise you?
Okay. There's a mistake something in this. No. This is, okay. Can I try to explain it? Because I'm messing with it. I think we're all confused.
Yeah, you can try to explain it.
Okay. When we were talking about deeds a little bit ago, I thought you were talking about the deed prepared in 2020, which signed 2731 Willow Spring Road over to me and Letitia.
Okay.
I didn't know about that deed until I got sick. Now, then my mom says, here is the deed, and my wife's attorney got the deed and went and recorded it. This is what I owe my mother for receiving that property, her and Letitia. For me and Letitia receiving the property from my mother, this is what I'm supposed to pay my mother. I don't own the property at 348 Mercedes Avenue.
So, I mean, you understand you're under oath right now.
I am under oath.
And you're saying that you never had this title put into your name for this property?
There's no way. This conveyance, as far as I know, the $94,000 is what I owe my mother for building that house up there at 2731 Willow Springs Road. 348 Mercedes Avenue is not mine. That's my mom's house. That's where she lives.
You state that you live now at 348 Mercedes Avenue.
I do.
Okay. Do you recall speaking to the Bay County Sheriff's Department 2 weeks ago?
I do.
Okay. Do you recall telling them you do not live at 348 Mercedes Avenue?
I did not then.
Okay. How long have you lived there?
Well, the truth is I'm bouncing around everywhere. I've been in St. Augustine with my brother for a month. Now I'm up close to the Alabama state line helping somebody on a farm. I'm living in their house. And I do have clothes hanging at 348 Mercedes Avenue. That's where my driver's license is. It just seemed to be, that's where my insurance for my truck is. It just seemed to be easier to call that home base. But I don't own that house.
Did you recently help your daughter buy a property in Florida?
I did not.
Okay. You heard Mandy say that you own an interest in at least one other property in Florida. Do you know what she's talking about?
I do not.
Okay.
My oldest daughter did recently buy a house. It had nothing to do with me.
All right, I'm gonna hand you one more document. Or I'm tendering at this time plaintiff's exhibit 1 into evidence.
All right, any objection to me looking at the, and again,
I object just because I ain't got a clue what is going on.
he
here.
just wants to know if it's okay for me to use it and
Sure,
trying to figure out what I'm doing.
Yes.
Okay, that's all that question means. All right, then plaintiff's 1 is tendered and admitted are you okay with me doing that, right? You can object if you want to. I just thought
I
you said
object, but I don't.
That's fine. It's tendered and admitted over defendant's objection.
Thank you, Judge.
Thank you.
No problem.
All right, now I'm handing you plaintiff's 2. Do you recognize that document?
I do.
All right, and what is that?
That is transferring the property. It's transferring the property at Willow Spring Road back to me and Mandy.
All right, and that is the current deed for the Willow Springs Drive house, correct?
This is the deed that Mandy's attorney recorded. Yes, sir.
All right, and that's a true and accurate copy of that deed.
Best I know.
All right, Your Honor, this one I tender plaintiff's exhibit 2 in evidence.
All right, I'm gonna let you stand on the previous objection, and I'm gonna put, that way you're protected. So it's, so plaintiff's 2 is tendered and admitted over defense's objection.
Just gonna hand that over to court reporter. Nothing further, Your Honor.
All right. All right, Mr. Campbell, do you have any other testimony you want to give or questions you want to get answered before we wrap this up?
Okay, so the deed from 2020, I didn't know about until I got sick. My mother handed that to me and my wife, told us what it was, said do not record it unless I died, James, or Pauletta Owen died. Okay? Now, the other thing, as far as I know, that's just a lien against 2731 Willow Springs that I owe my mother for her recording the deed, or actually my wife's attorney recording the deed. I owe my mom like $94-something thousand, the cost of building that house. I don't know why he thinks I own that property where my mom lives. I don't understand that one. It's gonna take somebody smarter than me to figure that one out.
Okay. Yeah, there's definitely some layers of this knot to untie, but that's not for me to
There's
do.
something wrong.
That's not for me to do. So, all right, my job is just to get it all out on the table. All right, anything else?
I hope not, yeah.
Okay. Anything else, Mr. Webb?
Yeah, I will just state as an officer of the court that I never received a settlement offer from James Campbell through his counsel. Also, I did conduct discovery in Spalding County, and I did receive responses from Pauletta Owens, which are not at all in line with what he's telling me right now.
All right. If you all want to go talk for a minute in the jury room or wherever, and if you have an agreement that you can reach, you can put that on the record. If not, I'm going to adjourn. So do y'all want to try to talk for a minute? See, this is what I'm saying. Y'all can talk outside of my presence for a few minutes if y'all want. If you reach an agreement, you can put it on the record. If you don't reach an agreement, you can put that on the record, but you don't have to. And otherwise, I'm gonna wrap this hearing up.
What do you think we ought to do?
So, I'm always a fan of folks talking. I'm going to tell you, if you ask me that, I'm always going to
He's gonna
say,
take advantage of me, but I wouldn't mind talking to him.
you certainly don't have to. All right.
He gonna try.
All right, y'all talk for a minute. And if, again, you're under no pressure, Mr. Campbell, to take anything you don't want to take. You hear me?
Take what now?
You don't have to take anything you don't want to take.
Oh, I won't.
Don't agree to something you don't want to, okay? All right, y'all talk. And again, no pressure for y'all, but any luck?
Afraid not, Your Honor.
Okay, didn't think so. That's perfectly okay. It's just always a good idea for folks to talk. All right, so Mr. Campbell, do you have any questions for me before we part ways?
No, sir.
Okay, then it's 4:37. I'm gonna draw this hearing to a close. I consider this for transcript purposes to be one hearing. I know there's two cases, but it's just everything got overlapped. So, anything else before I wrap it up?
Do you think we're done?
Well, we're done with the hearing today, but you're not done with the case because he has the right under Georgia law to continue seeking money from you until that money is satisfied. And so, no, we're not done altogether, but we are done today. So, and
Do you think you and I are done?
so I hope so.
Okay.
I mean, like I said, I'd love to see you. I don't know. I don't ever go to Panama City, but I hope I see you around Panama City one day, get to shake your hand, and you and I agree that this part of our life is done.
That'd be awesome, wouldn't it?
So that would be really nice. So, all right. Well, then that's it. Court's adjourned. This case is closed. Y'all have safe drives back, and good luck to you.
Thank you, Judge.
Thank you.
Well, thank you so much.
All right. Good to see you.